Once they arrest you, then you have to do a chemical test, a blood or breath test. Generally, the officer will tell you that you have an obligation to take either blood or breath test based on your agreement to get a driver's license in California. And you could choose between the two. Now, some officers will confuse you and say you have three options: either take a blood test, take a breath test, or refuse to take a test and I'll get a warrant. And people will say, oh, I'll just have you get a warrant. And that means that the officer has to present the probable cause that they had to arrest you on suspicion of driving under the influence, so that a judge would look at it and say, yes, you should get a blood draw, because that will prove what the blood alcohol level is. But when you do that and you say get a warrant, then that means that the officer can write down that you refused to take the test, so he had to get a warrant. And that refusal can be used by the DMV to revoke your license for a year or longer. But let's say that you agree to take a test. If you agree to take a blood test, some police agencies will go to the judge anyway and get a warrant that says they can draw your blood, because drawing your blood requires them to put a needle in your arm, which is pretty invasive. It's a search of your body and your blood in order to obtain evidence against you. So they really want it to be justified by a judge. A lot of agencies will allow you to voluntarily do that, and then they must make sure the blood is drawn in a medically sound way. They can't just have an officer grab a needle and stick it in your arm and pull out blood. It must be like a nurse, a phlebotomist, somebody else who's skilled in that. I guess some agencies do train the officers to do that, but most agencies bring in a nurse to do it or take you to the hospital to do it. If you choose a breath test, they normally don't get a warrant because that's less invasive, and that requires you to blow into a machine, and so they can get your blood alcohol level. If you try to blow in the machine and it doesn't register your blood alcohol level, then they will tell you have to take a blood test. But if you take a blood test or a breath test, you satisfy the obligation with the DMV. If you refuse to take the test, then they can draw your blood. They can even hold you down in order to get blood from you. And that's clearly a violation of your Fourth Amendment rights unless they're justified or have a warrant to do that. Some agencies will not hold you down. They will ask you to voluntarily to submit to the blood test once they have a warrant. That's your choice. Generally, if they get a warrant for your blood, and they take you to the hospital may ask you to sign a paper authorizing them to draw your blood. That's not required by the law, but it may be required by the hospital. But I think if you agree to take a blood test, but don't agree to sign that paper, that may or may not be considered a refusal by the court or the DMV. You may consent to anything that the officers ask you to do, and your consent is waiving your rights. If you consent to have your blood drawn, you're waiving your right for them to get a search warrant. If you consent to take the field sobriety test, you're waiving your right to object to that. The law says that they cannot use your refusal to take field sobriety test against you in court because they're voluntary. And they can't say that you exercise your Fifth Amendment right by not providing evidence against you, and therefore they can use that against you in court. That's not what the court says. If you refuse to take those tests, all they can do is talk about what evidence they had without those tests. If you refuse to take the test after you're arrested, that may be used by the DMV to take your driving privileges away. And some courts may use it against you in court to say you refused the test knowing that you had alcohol in your system. But normally they don't do that because they will draw your blood and get evidence against you. If they draw your blood and it may show that you had less than a 0.08 blood alcohol level, then they generally will not proceed on the driving under the influence case unless they find something else in your blood. But the DMV can still proceed on the case even if you have a low blood alcohol level if you refuse to take the chemical test, because that doesn't matter what your blood alcohol level is. Now, as a practical matter, if you are stopped for driving under the influence, you had some alcohol, but you also had other things in your system like drugs, street drugs, prescribed medication, or anything else, marijuana that's legal for you to have, and your blood alcohol level comes back as below a 0.08, then they can test your blood for other substances. And if they found blood alcohol level at some level and then other drugs in your system, they can say that combination would cause you to be impaired and proceed that way. Your constitutional rights, like I said, can be waived. You consent to a search. You can volunteer information, give them information. You can agree to take the test, understand their purpose. Without understanding their purpose, you can fail to challenge the police conduct. You can even go to the court. The police could violate all of your rights, and then you can go to court and plead guilty to a case that they couldn't prove in court, or they did it a violation of your constitutional rights. That's your choice. But I would think fight it. Anything the police ask you to do, it's often good to ask them if it's required or if it's voluntary. Sometimes the police will tell you something is required that's not, and then that could be grounds potentially for suppressing that evidence. If they say, no, you have to take field sobriety tests, and you actually don't, then you can say, I'm doing them because you're telling me I have to do them, but I wouldn't do them otherwise. Then those generally would be suppressed by the court because they're not being done voluntarily. Now, you can protect your Fourth Amendment rights by fighting anything that they've done against you that's not legal. Like that would be after you're arrested, you go to court and you say, they didn't have a reason to stop me. And the officer says, I stopped him because I wanted to talk to him about driving under the influence. Well, that's not good enough. But they can stop you if someone calls them and says, hey, this person is driving under the influence of alcohol. And then the police can stop you to investigate that, even if you're not violating any traffic laws. They have to prove that they have reasonable suspicion to arrest you for driving under the influence. That means based on all the evidence they had presented to them at the time. And if they did not have sufficient probable cause, let's say they had no evidence you were impaired, but still arrested you, then that can be thrown out because they didn't have probable cause to arrest you.